All right, 21-162-348. This is Michigan First Rehab versus Nationwide Mutual Fire Insurance. Matter is set before the court for a pretrial conference on today's date. The court did set up in order for discovery on a previous occasion and set the discovery closeout date for today's date. All right, your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff.
All right, thank you, counsel. Good morning to you. And for the defendant in this matter, your appearance at this time.
Your Honor, I believe Mr. Capone is running a little tardy today. He's in another pretrial. I would respectfully ask the court to pass on this matter for the time being, if the court is willing to do so.
We'll do so, sir, and I'll call it back shortly. Thank you.
Thank you, Your Honor.
The court is now calling case number 21-52689. This is Spine and Health PLLC versus City of Detroit. Today's date and time set for a review regarding this matter. For the plaintiff, Spine and Health. Have anyone on this case for defendant? Right, that's part of the 9:30 call. The court will recall that matter. Sure. And Ms. Norris, you're here on a default matter. Is that correct, ma'am?
It may be based on my notes. We did file an answer, and I don't think we've had a pretrial yet.
Let me. I know my officer took your case number, but right by me once again, the last three digits.
Last three of mine are 325. Unless the court didn't get an answer. Let me pull that away.
Oh, yeah. All right, so it's set for 9:45. Let me see. Do I have Sarah Troop on the Zoom?
Yes, Your Honor, I'm here.
I'm going to call the case a little early because both sides are. This is case number 21-165325. This is Jefferson Systems LLC versus Sarah Troop. Matter is before the court, set on for a pretrial status hearing, given the fact that the court has received the answer. Matters therefore joined, and court sets it up to see whether or not there is a scheduling order necessary, things along those lines. Madam Counsel, your appearance for the record at this time, please.
Good morning, Your Honor. Attorney Ashley Nonis, P77029, on behalf of plaintiff.
Thank you, Counsel. And Ms. Troop, you are Sarah, is that correct?
That's correct, Your Honor.
Okay, thank you. So this is the first hearing regarding this case, and I have received the answer that was filed. And I don't think, Ms. Norris, I believe that you were saying before I called the case that you had not received a copy or a document that was as an answer. Is that correct?
Oh, no, Your Honor. You had said that maybe this was for a default, but I stated that we did receive an answer. So I did have an opportunity to review that. Based on our answer, we have been trying to contact the defendant without any response. So I'm not sure if maybe you want to put us in a breakout room and see if we can resolve it today. If not, then obviously I would just ask the court for a scheduling order.
Right. This is a claim that sounds in $1,290. I think worthwhile for the parties to talk about what the differences may be in here. As I looked at the answer, one of the things that pointed out is the defendant disagrees with the amount. So I'm gonna put the two of you, Ms. Triple, I'm gonna put you in the breakout room with counsel who represents the plaintiff in this matter. Let's see if we can talk about this and see if there's a way to get this resolved. It does look like this was a debt that arose from the use of a finger hut type credit card situation. And we'll talk about it to see if I can get it to go with that. So you're gonna get a notification from Ms. Troop to go to breakout room number 1, and the attorney is going to be there to represent the other side as well. So in just a second, I'll go through the technology. There you are.
Oops, can you do it one more time? I'm sorry. I pushed I hit join, but it didn't go through. I'm sorry. Oh, wait, I think I.
All right, and I'm back on the record in circuit 21-162-348, Michigan First Rehab versus Nationwide Mutual Fire Insurance. Mr. Coulter previously entered his appearance regarding this matter. I believe that the plaintiff, I believe that other counsel for defendant is here at this time. Your appearance at this time, counsel.
Good morning, Your Honor. Kevin Capone appearing on behalf of the defendant Nationwide. Apologize for being late, Your Honor.
Not a problem. Counsel spoke up for you. Let me know that you were at another hearing. I like that kind of collegiality.
I appreciate that.
For the record, indicate your P number.
P number is 82518.
All right, thank you. So I know that I set this up on a bit of a scheduling order and then brought the matter back on today's date. Somebody update me on what the status of things are. How far along that point?
Your Honor, we exchanged written discovery. I think that's all set. The only other portion of discovery left to complete is Mr. Dawson's deposition, which I have scheduled for February 23rd. And I spoke with Mr. Dawson. I had to reschedule it because he didn't get notice of it the first time, or there was some miscommunication, but I have been in contact with Mr. Dawson. He's advised that he would appear on that date. So as soon as his deposition is concluded, I don't anticipate any further discovery after that. So I think that's all we need to do. So to wrap this up, discovery wise.
Thank you, counsel. Anything to add to that at this time?
Nothing to add to that, Your Honor. I did just recently file my appearance on this case, and I was looking to see if there's a present scheduling order on it. I'm sure there is. I didn't know if it was published to the Register of Actions or if it's a separate order.
It is a separate order, but it should be noted on the Register of Actions. I issued that order on November the 30th, and I had the discovery cutoff date as today's date, the 14th. And obviously, the interest of the court is that if parties are moving along, and if there's a little more time needed, then obviously that makes sense to go ahead and finish it out. So I will extend the discovery for the next 30 days to allow for the completion of the pending deposition. And obviously, if other parties believe that there's something else out there that you want to try to clean it up over the next 30 days. I'm going to set a hearing some 30 days hence. I can find the dates of my photograph. Just one. Looking for my date.
We'll check your office. Did you go to your office?
No. Okay, here we go. So we're gonna set that. Thank you for your patience in this regard. We're gonna go ahead and set that for the 17th of March, March 17th. That'll be your return date. And I'll set that at 9:45.
Thank you, Your Honor.
Thank you, Your Honor.
That's what we'll see at that time. Discovery is extended, court finds good cause for the adjournment of this matter.
Thank you, Your Honor. Have a good day.
Thank you, Your Honor. Thank you, Mr. Capone.
And we're back on record regarding the suffix 325. That's Jefferson Capital Systems versus Sarah Truth. Thank you to the two of you. I know you went to a breakout room. Welcome back. Councilman Starks, if you update me on where things are at this point, please.
So I think we're gonna have to open up some discovery. I would ask the court for maybe 60 days, and then after the 60 days, we would either ask for another pretrial conference or a motion date.
All right. So is there? Let me try to pry into this a little bit. Ms. Troop, you're not bound by what you now, but I need to know something just to see if this case can move forward. Is it your position that you don't owe anything on this case?
Yes, Your Honor, it is.
So this was not, you're saying this was not your car, you didn't use it, you didn't expend any money or anything on this, correct?
Correct. This is not the debt that they are referring to is not mine, Your Honor. Correct.
Okay, all right, very well. So what I'll do is I will set it up on I will open discovery on a 45-day discovery track. What I'm going to do is I will set that date to bring this back on the 31st. Actually, I'll bring this back on the 4th of April. That's going to be 4/4/22, and that's going to be at 9:30 a.m. That's going to be the next action date. Discovery will be open through that date. Also, I'm setting that date as a motion hearing date. That means that if you file a motion, whether dispositive or non-dispositive, it can be heard on that date so long as you provide at least 10 days opportunity for the other side to respond. So as long as you file your motion and that motion filing is 10 days before the hearing, or allows the other side at least 10 days to respond, I will hear the motion on the 4th of April. So the opening of discovery, Ms. Troop, allows the parties mutually to exchange information, to request information, to send out a request to admit, to send out questions that are in the form of interrogatories, even to do something as far-reaching as taking a deposition and other forms of requests. You can make requests of the plaintiff in this matter for information, documents, etc., and they can make requests. Those items are time sensitive. They have to be responded to. If responded to, they constitute a default. If not responded to at the time of permitted. So you'll be receiving some discovery items, and you can send out some items requesting documents yourself, and the other side usually is required to respond. I also allow in this case the filing of motions. A motion is a request for a hearing that a judge would take action on a particular position. So that if you receive a document asking you to do something, you will have 10 days to respond to that. And if you don't respond to it within that 10 days, that's like a default. So if you see something in writing, setting the hearing for the 4th of April, you got to make sure that you file something in response to that because it will be heard on the 4th of April, again at 9:30 a.m. Besides, we'll receive a copy of the scheduling order that the court has this record. It will have the same information that I've indicated, and we will also have, of course, the court date again at 9:30 a.m. Okay. I will with you at that time. Good day to you.
Well, thank you, Your Honor. There's just one thing I want to clarify on the record, if I may. Based on the defendant's answer, she does admit that she had a card at one point. I just think that.
1 second. I'm sorry. I interrupted you because I was trying to say something and then I was off
Oh,
track.
sorry.
So hold on 1 second. Ms. Troop, I didn't want you to hang up because Ms. Norris said there was something else she had to say. So hold on a second. Go ahead, Ms. Norris. I'm
Yes.
sorry.
I'm sorry, Your Honor. I didn't mean to interrupt you. I just wanted to clarify for the record that based on Ms. Troop's answer, she does admit to having a card, but based on the date, she thinks that this might not be her particular card. So I just want to make clear that it's not a complete allegation of fraud. I think there may just be confusion as to dates, amounts, things like that. So I just wanted to state that for the record in case we do have to move forward, that the court's aware that there isn't exactly a full dispute as ownership of a finger card.
All right, got you. And that's what the discovery process would help to clarify.
Right.
So we're bringing that information to the court. And no, you didn't interrupt me. I interrupted you as you were talking, and I was trying to get to Ms. Troop so that she would not hang up because we were at the hearing. All right, so the is on the record, and I will see the two of you on the 4th of April at 9:30 a.m. Good day to you.
Thank you, Your Honor. Have a good day.
And the court recalls 2152-689. This is Spine and Health versus City of Detroit. The matter is before the court set for a review hearing on today's date. I think I saw someone from the city on this matter.
Good morning, Your Honor. Philip Hildner here for defendant.
All right, thank you. And just put your P number on the record if you will, Mr. Hildner.
Oh, of course, yeah, P77913.
All right, thank you, Councilman. Good morning to you. When I called earlier, the plaintiff did not respond. You were not here. Let me see if someone is here for the plaintiff this time. Your appearance was Spine and Health. Anybody here on that one? All right. So what's going on this case? I'm just going to update, sir.
Yes, Your Honor. We have a settlement. I would say, Your Honor, there is. We've agreed on a number. We have city council approval. We are in the midst of one little detail on the release, whether it needs to be changed or not. But other than that, I think we have resolution of this case.
All right. And so you were saying, Ms. Hildner, that you already have city council approval, or are you awaiting that?
We have approval.
Okay. All right. So what I'm going to do, if it's okay with you, I'll go ahead and issue. I don't know if you've seen one of my orders before. I'll go ahead and issue an order that the case is dismissed and would be automatically reinstated if the case is not finally resolved, and if dispersal of funds are made, that would constitute a dismissal of prejudice.
Okay, understood, Your Honor.
All right, so I'll issue such order. You'll get that from me in the next couple of days. Thank you for the update, Counselor.
Yes, thank you. Take care.
Counsel Mackey?
Yes, Your Honor.
All right, let's see, which one are you on, sir?
I am here. Would you like the case number or the case name, Your Honor?
You give me the last three digits and
571 are the last three digits.
all right, this is case number 21-160-571. This is Align Rehabilitation LLC, I'm sorry, versus City of Detroit. And the matter is before the court. Looks like I set it for a status conference. And I see Mr. Hiller changed sides, but size of the computer, but he's back. Your appearance for the plaintiff first of all in this matter.
Good morning, Your Honor. Fahad Mackey on behalf of Plaintiff Align.
And your P number, Ms. Mackey.
82776, Your Honor.
All right, thank you. And Counsel, you previously had your appearance for the City of Detroit, Ms. Gilmer. Good morning to you again, sir.
Yes, good morning again, Your Honor.
All right, so what's going on here? I do see that there is a motion for summary disposition that's been filed in this matter. So somebody update me. What's the status of things?
Yes, Your Honor, that would be my motion for summary disposition. And I think we're just awaiting argument and a decision on that motion.
That's correct, Your Honor.
All right, very well. So why don't you go ahead and proceed at this time on your motion for summary disposition, Counsel May.
Thank you, Your Honor. This is the City of Detroit's motion for summary disposition pursuant to Michigan Court Rule 2.116C7. Align Rehabilitation plaintiff is claiming personal injury protection benefits under the No Fault Act on behalf of Charmaine Stampley. But before they filed this complaint, the City of Detroit had settled Miss Charmaine Stampley's own lawsuit that was in Third Circuit Court. As a part of that agreement was resolution of all outstanding bills, unless that provider had filed their own lawsuit. And at that time, Align Rehabilitation had not filed their own lawsuit. So contemplated in that settlement would be Align Rehabilitation's bills. We had City Council approval of that settlement on June 1st or 2nd. Align Rehabilitation filed their complaint in August, so 2 months after. We had no record even of an assignment. We acknowledge that Align Rehabilitation doesn't need an assignment, but we didn't even have an assignment. They hadn't pursued the bills on their own behalf, so there was no reason for us to believe that we weren't resolving those bills in good faith when we settled with Charmaine Stampley. So we believe we've already resolved these bills. They, at this time, since they were settled, they can't claim them on their own behalf. I believe there's a statute right on point, which is MCL 500-3112. It states payment by an insurer in good faith of personal protection insurance benefits to or for the benefit of a person who it believes is entitled to the benefits discharges the insurer's liability to the extent of the payments unless the insurer has been notified in writing of the claim of some other person. So our argument is simply we paid those bills in good faith. We had no notification in writing that someone else would be claiming those bills. And so this case should be dismissed under MCR 2.116C7.
All right, thank you, counsel. And I see that you did file, you did file a written response to the motion for summary disposition. And obviously this issue comes up quite frequently in the current environment. And counsel, your argument at this time in opposition to the motion.
Your Honor, thank you. The patient, Ms. Stampley, filed her lawsuit on October 28th of 2019. At that time, pursuant to MCL 531.10 subsection 4, these claims had not accrued. These claims accrued on July 27th, 2020 through August 20 of 2020. One issue with the defendant's motion is the fact that it doesn't include a case evaluation summary or a supplemental complaint, which would have added these claims to Ms. Stampley's underlying lawsuit, and then which the city of Detroit would have been able to argue claim preclusion, and that these claims would have been included in that lawsuit based on the pleadings. And therefore, these claims being in the pleadings of this lawsuit would be dismissed because of the prior settlement, adjudication, et cetera. So that's the first problem, and that's not properly supported. There's no evidence offered by the city of Detroit in their motion to show that these claims were actually a part of Ms. Stampley's lawsuit, that they were negotiated and that they were subsequently paid. Based on that reason alone, this motion should be denied. But in addition to that, Your Honor.
Let me stop you for a moment before you go to the next argument. It seems that you're saying the first argument, but it seems like there are two parts to this first argument. You're making an argument regarding the accrual of the claim as a basis for not allowing conclusion. But then you also argue that that the city in the litigation process should have taken other litigation steps that would have provided additional notice to other claimants.
It's not the city that should have taken the action, Your Honor. It would have been the plaintiff, because the plaintiff would have had to claim these bills. They would have had to claim this. Really, it's a loss that they would have claimed. And that loss has to be claimed either through a supplemental pleading, which adds these claims to the complaint, because these are separate and distinct claims pursuant to 531.10 subsection 4. That was never done. The only other alternative would have been a case evaluation summary that added these bills, that presented these bills as part of the claims, and then pursuant to that were negotiated and then settled in good faith by the city of Detroit. So that's the first issue. The second issue, Your Honor, is the fact that the defendant concedes that they had notice of this lawsuit on August 11th of 2021. They never mention when they received my client's bill. And I know they rely on the physiatry case, which is predicated upon the fact that a provider needs an assignment. And I argued this issue in front of the Michigan Court of Appeals. I didn't argue the physiatry case, so luckily the loss didn't come on my watch. However, I know that the Court of Appeals really struggled with the issue of, well, if you don't have notice of the assignment, then there's no way for you to file a lawsuit. And therefore, any payment that's made on behalf of an insurer or the city of Detroit in this instance would be a payment made in good faith, and it would discharge the liability pursuant to 531.12. However, in this case, we don't know when the bill was received by the city of Detroit, and that's not in evidence, and it should be, because that would directly go to notice. Once you receive notice of a bill at this point, under the No Fault Act, because providers as of June 11th, 2019 have independent standing, that is notice of a claim in writing. And thus, a payment made to another party who's actually not the real party in interest, considering my client has independent standing, would not discharge the city's liability. But in this case, I think it's even worse, because although the city may have approved the settlement in June of 2021, we don't know when the check was issued. And my experience with the city of Detroit is that takes forever. So even if the case was settled in June of 2021 and our assignment, or I'm sorry, our lawsuit was received on August 11th of 2021, and the payments had not been made, then the city was in the best position to file their own 531-12 motion to the court in the underlying suit, saying we have a settlement, we have an additional claim that's now being pursued, and it would be up to that circuit court judge to provide an apportionment of the settlement to the interested parties. But that didn't occur. And while also the issue is it's not even mentioned in the defendant's motion. So the motion's not properly supported, one, in terms of the claims that were included in the underlying suit. Two, it's not properly supported in terms of notice of this claim because they don't even mention when they got the bill. So there's no way Mr. Hiltner can argue that they never received a proof of my client's claim because it's not admitted into evidence as part of this record. So any representation Mr. Hiltner would make right now under his own motion, because this is a C7 motion, should not be considered by this court. So on that basis, this motion should be denied as well. In addition to that, Your Honor, I think it's very clear that well, actually, Your Honor, based on that, honestly, I have nothing to add unless you have any questions.
All right. Thank you, Counsel.
I'm sorry. I would like the opportunity to respond, Your Honor.
Yes, it's your opportunity at this time. Go ahead, Mr. Hilton.
Okay, thank you. So the first thing I have to address is the brother counsel's claim that we didn't state when we received the bills, but that actually is addressed directly in my motion. Exhibit C to my motion is request for admission answered by plaintiff saying that they had submitted their bills to the city of Detroit in August 2020. So that would be 10 months before we settled with Ms. Stampley. So they were undeniably a part of our claim file before we settled with Ms. Stampley and almost a year before plaintiff in this matter filed suit. So we had the bills as part of our file. We had notice of the bills, but we had no notice that Align Rehabilitation would be independently claiming those bills. And I would also just point out that plaintiff's argument just ignores the statute, MCL 500-3112, which says we're discharged of liability. If we made the payment in good faith, we are discharged of liability. And the last issue is that plaintiff raises is that the check wasn't sent by the time they filed suit. That's likely the case. It takes some time for the city of Detroit to issue a check, but that doesn't mean we didn't have an agreement with Ms. Stampley. If we were to turn around to Ms. Stampley and say, well, Align Rehabilitation has filed suit, so there's, the deal is off, we'd be facing a breach of contract lawsuit because we had already settled with her. So those are just the 3 points I would make in response.
Your Honor.
And before Ms. Rocky comes back, Ms. Rocky raised some issues about the claim accrual. I believe that you answered it, but I didn't want you to miss that as he made significant arguments at the outset of his response to your motion regarding whether or not the claim had accrued sufficiently or for there to be preclusion here. I know that I understand you to say that even though at some point the city had the bills from this particular claimant, that there was no lawsuit that was filed, and in reaching the agreement with the principal plaintiff there at circuit court, that all of these bills and obligations up to that time were included in that resolution. That's correct, what you're saying, Mr. Hill?
Oh, and I'm sorry, I think I just missed, I couldn't hear what you said at the very end there, Your Honor.
I was saying, based on that summation of your argument in regard to the accrual argument, is that basically your argument in summation that the accrual argument is of no weight because of the fact that You did have bills that the plaintiff, there in circuit court, included those bills in her resolution or settlement of this matter.
Yes, Your Honor.
And, go ahead, I'm sorry.
Oh, and I also would point out that he said we didn't have a case evaluation summary addressing those bills. That was one other item. Our Exhibit E is a document that we received from Ms. Stampley's attorney during settlement negotiations when we were sorting out how many bills we actually think are outstanding. And that document did include Align Rehabilitation's bills.
All right, thank you. Go ahead, Mr. Mackey. I know you had something else to bring in.
Yes, sir. That document is still not a supplemental complaint and it's not a case evaluation summary. So I still would stand by my argument. But I think based on Mr. Hiltner's representation, again, it's not part of the record, so it's not really reliable. But even if it was, if the city had proof of my client's bills in June of 2020, my client had independent standing as of June 11th of 2019. So under 531.10, or I'm sorry, 531.12, that is written proof of standing because my client does not need anything besides having a bill under the new No Fault Act, well, not so new No Fault Act, in order to pursue its claims. The only reason why an assignment was ever needed is because a provider didn't have independent standing. Independent standing is no longer an issue as of June of 2019. So when 531.12 requires a claim or notice of a claim in writing, a bill from a medical provider is notice of a claim in writing. And there is no other requirements under 531.12 for a medical provider. So my client's responsibilities under 31.12 were in fact satisfied. And in fact, it's the cities that wasn't satisfied. And I think that when Mr. Hiltner said, yeah, the check wasn't issued when we received this lawsuit, I think is exactly the issue, is that you have a tentative settlement and you have the money, you're in possession of the money, and then you receive a lawsuit of a claim that is viable that conflicts with the settlement. And instead of filing a 531.12 motion appropriately and having the circuit court judge apportion the settlement proceeds or carve them out or do whatever they may decide based on the judge and their discretion, they just issued the payment. And that's not good faith. Receiving notice of the claim a year before the settlement, and then receiving the actual lawsuit for that claim, and then still ignoring it and issuing the proceeds, and then coming back here and saying, oh, well, we made a payment in good faith. It's not good faith, Your Honor, because they had notice of a conflicting claim. My client did file suit. They had notice of my client's claims even a year before they settled in the underlying suit. So the good faith argument is out the window. And in addition to that, it's not clear if or when these bills were negotiated, when they were included, when they weren't, because we don't have an affidavit from the handling adjuster or representative from the city of Detroit saying when these bills were received, when the check was issued. There's a lot of deficiencies in defendant's motion, which cause an issue for granting the motion based on the record that's been put forth before Your Honor.
Mr. Mackey, why would your remedy with respect to the failure to give notice for potential apportionment, why would your remedy in that regard not be for the circuit court on an attack as it relates to the claim settlement?
Well, Your Honor, my client was not a party to the settlement. The only parties to the settlement between the city of Detroit and Ms. Stampley were Ms. Stampley and the city of Detroit. And because my client,
I understand that, but you indicate that one of the things the city should have done at that time was to file something before the court for an apportionment with respect to the settlement because the lawsuit was likely filed before the issuance of the check. Why would your remedy not be then with the circuit court to attack that even now as to whether or not the funds were apportioned properly?
Well, the issue, Your Honor, is that the funds are already gone, and the case before the circuit court is closed. And I myself or my client were not aware that these bills were claimed in that lawsuit, and that lawsuit had settled. And in addition to that, the reason why I ask Your Honor to put that responsibility on the city of Detroit is because that's what 531.12 guides us to do. It's the city of Detroit has the responsibility of making a good faith payment. The city of Detroit has the responsibility that when they're given notice of a claim, they have certain remedies that are available to them. And one of them is a 531.12 motion to apportion the settlement. And they didn't do that. And now they rely on 531.12, ironically, to say that they made a good faith payment and that this case should be dismissed based on the previous litigation. But this, go ahead, I'm sorry.
Thank you, Ms. Mackey. All right, Mr. Hilder, you get the last word on this, sir.
Right. Just very briefly, if them submitting the bills, plaintiff submitting bills in this case, or Ms. Stampley submitting bills on behalf of her is somehow noticed that they're going to file suit, it would be impossible for an insured to ever settle with a claimant because it would be forever in limbo whether or not that that provider was going to file suit on their own behalf or not. Unless the provider's already filed suit or otherwise given notice that they intend to pursue the bills on their own, then we're settling those bills from all the providers that we're aware of. One other issue is that the 531.12 says that if there's doubt about the proper person to receive the benefits, the insured, the claimant, or any other interested person may apply to the circuit court for an appropriate order. The city's position would be that there wasn't doubt about the appropriate person to receive benefits. Certainly not at the time we had settled with Ms. Stampley. It seems like any concern that Align Rehabilitation has would be with Ms. Stampley and her lawyer about who is entitled to what benefits. When we settled with Ms. Stampley, that was decided on June 1st. We had no reason to believe plaintiff would be pursuing those bills or there'd be some sort of conflict.
All right, thank you. The court has listened to the arguments on the plaintiff's motion for summary disposition in this matter. And as has been set forth herein, the plaintiff's argument in supporting the motion relates to MCLA 503.12, and of course, in bringing the motion, the defendant in this matter relies upon MCR 2.116 C7. In that particular provision, the motion for summary disposition addresses whether or not there has been a release of private judgment that would preclude the current action from going forward. And in this case, the plaintiff, the defendant, claims that there was a good faith payment. It is undisputed that a case in circuit court was resolved, and that when that case was resolved, it was resolved with the, if you will, principal plaintiff, I should say the claimant, Charmaine Stampley, and that it's not disputed further that at the time that this the resolution was had in circuit court, that at least from the city's perspective, that they had notice of the bills that were being offered by the plaintiff here, that is Align Rehabilitation, and that those those claims were included as a part of a resolution that was reached in circuit court, and that resolution was global in nature. And the once a settlement was reached, then the defendant takes the position that there are no other obligations that are outstanding because there was no other lawsuit that was pending regarding this matter, such that it would not be included in the settlement. So the issues kind of raised here is whether or not the plaintiff, having submitted bills to the city of Detroit, was sufficient notice of an intent to pursue a separate claim. And when I look at this on balance, where there has been notification that there is that there are bills out there, that is something that's done in the normal course of things, that bills are submitted, and the plaintiff typically pursues a lawsuit, and that plaintiff is in control of the various aspects of the claim, one of which was that there were bills and obligations that were due to the plaintiff here, a line we have. Those were taken into consideration at the time that the settlement was reached, and the plaintiff signed off on it, if you will, and the settlement was ultimately approved, and the case was resolved in that matter. The defendant here raises the issue of whether or not the plaintiff, having received the city having received a notification of a lawsuit after the matter had already been pending before the court as a resolution, whether the city should file something separately for apportionment, and whether or not their failure to do so violates the provisions of 503.112, that any settlement resolution be one that's made in good faith. I've reviewed everything that has been a part of the motion for summary disposition and the response to the motion for summary disposition. I cannot, on balance, find that the city acted in bad faith in settling the matter, and that the city acted in any type of bad faith in trying to get the plaintiff here to pursue their claims separately. This statute allows for the city or those similarly situated as the city of Detroit and ensure to, in fact, resolve a claim with the underlying claim where there is no other pending lawsuit, and where they are otherwise acting in good faith. And the good faith provision there certainly addresses whether or not an insurer is attempting to evade or attempting to circumvent the rights that may exist with parties that might bring a claim separate. The fact that no lawsuit was filed until after this matter was in fact resolved by the claimant who had the authority to in fact resolve the claim is essentially enough here, unless the court sees something that shows that there was some act of bad faith. I don't see any bad faith here. The matter has been settled in circuit court. It seems to me that there may have been rights that could have been asserted by the claimant, and rights that could have been asserted by the plaintiff in this matter, even as the settlement was pending before the court, or even after it was resolved with the court. And that is to file some motion to reopen that and ask the court for reapportionment. That is something that someone believes to be appropriate in this matter. I'm not suggesting that should be done, but that might appear well. It might be one of the remedies here. Having reviewed everything concerning this motion, I do find that the claim that is submitted to this court at this time would seem to be precluded by the resolution that was reached in the circuit court, and that has been asserted within the context of the city of Detroit's motion for summary disposition. Therefore, under the provisions of MCR 2.116C7 and under the statute MCL 503.112, the motion for summary disposition in this matter will be granted at this time. So
Thank you, Your Honor.
All right, submitted order, the court will sign off on it. Withdraw the application.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Good morning to you, counsel.
Good morning, Your Honor. How are you?
I am good, sir. I put you on the Metro Med pain management, correct?
Yes, Your Honor.
All right, that would be case number 21-162798. This is Metro Pain Management, Metro Med Pain Management versus City of Detroit. Your appearance at this time, counsel.
Joe DeCruz on behalf of the plaintiff, Your Honor. P84445.
All right, thank you, counsel, and again, good morning to you, sir. I don't see anyone from the City of Detroit on this matter at this time. Tell me what's going on here, sir.
All I have in my file, Your Honor, is that this was set for a pre-trial. I do believe we've exchanged discovery. No, Your Honor, I do not see that discovery was sent. We do have a witness list. We do have initial disclosures. As is the case with, we have deposition notices, but nothing is in the way of discovery yet from the city or their counsel. So there's been no formal offers, not really a lot of talking either.
All right, so did you say that there was a deposition pending or something?
No, there was a notice of one, but I don't know if they've subpoenaed them or not yet.
All right, so Ms. Gallant, I believe, was here last time, but I don't see anybody here today. Have you reached out to any of them to try and see if we can get a hold of anybody? I'll wait just a bit if you counsel to see if we can get it.
Yes, Your Honor, I can text Miss. I don't have Miss Gallant's number, but I believe Miss Mills is on this as well.
Yeah. Okay.
So I'll send them a quick text, Your Honor, and see if anyone can come on.
All right, sounds good. I'll stand down for a few moments.
Okay, thank you, Your Honor.
Good morning, Your Honor. I apologize for being late. I didn't have this on our calendar.
Not a problem. We are on the record in 21-162-798. This is Metro Pain Management versus City of Detroit. The matters before the court after setting a pretrial scheduling order. Today is set for a pretrial conference. I know Mr. Group is there. Your appearance, counsel, on this matter.
Yes, Your Honor, Jane Mill for the City of Detroit.
Your P number, if you will, for records.
I'm sorry, P38251.
All right, thank you. Plaintiff's counsel was indicating, and I see that he's on mute there, sir. He was indicating that there's not much had been done in the way of discovery here. There was notice regarding deposition, but that not going to take long. So why don't you update me on where you think this case is now? Mr.
Joe?
You there, Joe?
I see his square.
He spoke with me just a little earlier and indicated that.
Your Honor, I don't know if he can hear me. I think we can resolve this case. There appears to be a very small amount at issue, and I just need to talk to Mr. DeCruz in a breakout for a second.
Yeah, and as soon as we get his attention, I'm gonna.
Okay. Sorry to keep you waiting this minute.
Oh, no, it's not a problem, not a problem. We're moving along well here. It's Monday morning and Matthew Stafford won the Super Bowl.
Yay. I may even have his cell number. Let me see if I can. No such luck. Great. Joe.
I sent him a
I'm
chat.
sending him a chat message. Maybe he'll see this. Joe.
Yeah, I just did that.
Okay. He was kind enough to text me on my cell, so. Okay, he's in voicemail. He's on his own. He's on. Okay, it's another text message.
Oh, there's Joe. He's back.
Oh, Joe, thank you for calling me.
No problem.
All right, and Mr. DeRue, Madam Council had indicated that speaking of breakout might be helpful in regard to this matter. So I'm going to send both of you to breakout room number 1, and I will wait. Your return.
Thank you, Your Honor.
So he says, what's your name? He says you're across the street. You must be across the street. You can't be at the 36th. What's the case? So you don't have your case. Your case.
Your favorite troublemakers are back, Your Honor.
Speak for yourself, Joe.
Judge knows I'm the trouble of them all.
Well, we have some good news, Your Honor.
It's at this point that the judge says nothing. Go ahead, Ms. Mills.
Looks like we have a tentative settlement. Joe has to get authority from his client. This is, I think the figure is 1,420 you have authority for.
Yeah, I have authority for 1,420. The city has authority, or the city. There was a communication, not from me, but that said 11 something. And I'm gonna go and try to see if I can get that from my client, and if not, then get his final position. But we're within $150 of each other.
Take it out of your pocket, Joe. We can be done. So we're asking for, if we can, Your Honor, 14 days, and then we'll probably be back with, we're done. We don't even have to have city council approval. If it's this number.
All right, very well. So I will go ahead and send it over for just a couple of weeks for just to review. And,
Okay.
And see if we got everything, got a wrap on everything. So let me go ahead and set it. Yeah, for the 28th of February, 2/28.
February 28th at 10 o'clock.
10 o'clock.
Okay, thank you, Your Honor, and thank you, everybody, for dragging me in late.
Thank you, Your Honor.
All right, bye-bye.
Bye-bye.
All right, thanks, Joe. Right.
All right, all right, all right.
Yeah. She'd be trying to help not mess up. Lot of stuff. We didn't do too much.